B injured her eye after failing to close a safety gate on a machine as instructed. She was also not wearing mandatory safety goggles as required by her contract of employment. Which of the following is this an example of? So B has been injured. When we look at what caused the injury was caused by B failing to follow her instructions. So she failed to close the safety gate on the machine as she had been instructed. She failed to wear the safety goggles as required by her contract of employment. So what is this an example of? Well, contributory negligence. This is when the defendant's liability is reduced due to the claimant's behaviour. Well, in this situation, the defendant, the employer, has no apparent liability. So the employer has provided instructions, they've provided safety goggles, they've included all of this in the contract of employment. So there isn't really a liability to reduce. On the other hand, the valenti non fit injuria translates roughly as to a willing person, no injury is done. In other words, what's happened here is B has failed to close the safety gate. She's failed to follow the instructions on the safety gate. She's failed to wear the goggles. And the courts would say, well, that action, those behaviours, effectively you have consented to the risk that you are exposing yourself to. And therefore, we would see this as valenti non fit injuria. Now, just to cover the other two options, just to demonstrate why they are incorrect, novus actus interveniens, a new action intervenes. So this would be the case if something happened between the defendant's negligence initially and something else happening which fundamentally changes the situation that could not have been reasonably foreseen. That's not the case here. And then finally, res ipsa loquitur, the facts speak for themselves. This is used to reverse the burden of proof. So in some situations, the negligence is so obvious, there is no other logical explanation for how this situation may have arisen other than negligence, and therefore the burden of proof is shifted onto the defendant to show that they are not liable. So, for example, if you went in for an operation and you woke up and a week later you were really, really ill, and it was discovered that various large medical implements had been left in your body after the operation, that would be an example of res ipsa loquitur. It would be very difficult to explain how on earth those medical instruments got into your body other than through the operation. And it would be very difficult to explain how those could have been left in your body without somebody having been negligent. Now, none of that is the case here because the defendant in this case has not done anything that is obviously negligent. So therefore, what we've got here is B has effectively consented to an injury valenti non fit injuria.